Are you a property buyer or are you a property owner? Are you aware that on an offer to purchase, there's a clause that is called a voetstoots clause that can affect you badly if you don't even understand it while you are buying or you're actually selling the property, right? So if you want to find out about this, stick around until the end of the video. Let's get to it, shall we? So in most sales agreement of an immovable property, they contain a clause in terms of which the purchaser agrees to buy the property voetstoots, right? So the term voetstoots is a provision in the agreement which stipulates that the purchaser buys the property as it stands and thereby indemnifying the seller against claims for damages in respect with any defects on the property. So whether the defects in that property are what we call latent defect or defect that are potent, right? What does it mean, latent defect or potent defect, right? So in terms of potent defects, those are the defects that are visible, right? You can actually, when you are walking around the property, you can actually pick them up. They are visible in the eye, right? And the latent defects are hidden and are not discoverable even through a reasonable house inspection. So you need to understand these differences, right? So the clause that is called the voetstoots clause is designed to protect the seller. But the South African case law and the legislation provides for certain instances in which the seller will not be able to raise the voetstoots clause as a defense in terms of a claim against damages, right? So it must be very, very clear to you to understand that you cannot use, as a seller, you cannot use this voetstoots clause all the time. There's some instances where the buyer will have an advantage because of what the clause is saying, right? So this is the thing that the seller cannot. Let's break down the things or the instances in which the seller cannot rely on this voetstoots clause. If you remember last week, I spoken about house plans that are not approved by the municipality. If the house plans are not approved by the municipality, you as a seller, you will be demanded by the purchaser that you should provide those approved plans at your own cost. So in that instance, you will not win it, as I said, because of the Consumer Protection Act, right? But in addition to that, if you as the seller was aware of the latent defect that exists within your property and you have deliberately concealed or failed to disclose that there is this defect in an intent to defraud the purchaser, then in this case you cannot defend yourself, right? You cannot defend yourself and you will not win this case. So what does it mean? It means there's a new practice that there's what we call a disclosure form. Most of the sellers that I assist them with, the seller to sell their houses, they are aware of this form where we list everything that is okay or everything that is not okay in the property, right? So this disclosure form is used to describe all the defects on the property, and the seller on this disclosure will make a declaration confirming that the items that are listed constitute a full and a proper disclosure, right? So this disclosure form will be used in cases there's a dispute that arises with regards to the condition of the property. So we can actually refer back to what was actually agreed upon or what was actually disclosed as the defects that the property has, right? So one of the things that you must take note of is that the voetstoots clause is not applicable to property transaction where the seller is selling the property in an ordinary clause or of business, right? This is typically applied by developers, builders, or investors, because this in this scenario, if there's something wrong within a certain period in the property in terms of defects, the developer in most cases is willing to come and fix that at their cost. So that is a clause that is called the ordinary clause. So which is the more or less the opposite of the voetstoots clause. But it must be clear for you as an owner of a property that you are selling that you must disclose everything to the new owner. Whether the house has a structural problem, has plans that are not approved by the municipality, or anything wrong with the property, you need to disclose that to the purchaser. And the purchaser from their side, they need to buy the property while they are aware what is actually the condition of the property. And they in turn must sign the disclosure document that they bought the house while being aware of these cases, right? If you have any questions with regards to this clause and you need more clarification, just hit that comment section and then I'll be on you. I'll answer you as soon as possible, right? So if this video is helpful for you, please share with your friends, because maybe they need this information also. And don't forget to subscribe and to like this video, right? Because when you subscribe, when you like, or when you comment, YouTube shows this video to more people, because it is they see it as helpful to other people. Don't forget, in this channel we talk all things real estate, all things personal finance, to make sure that you are not the passenger of your financial life, but you are actually the driver. Because if you are the passenger of your financial life, somebody is driving it. And when somebody is driving it, guess who to benefit? They're gonna drive it to benefit themselves and not you. Cheers. I will see you on the next one.